Good morning, good evening, good afternoon. Let's see if and when we go live. Good. It looks like we are live. Perfect. So on my second monitor, I have the chat open. You won't be able to see it, but today we're going to go over a motion to dismiss that was filed by the defendant, Mayor Paul Sidney Alfrey, in a roundabout way because we're looking at the opposition to the motion to dismiss, or at least a selected portion of it. Hello, Bazinga. We're looking at a selected portion of it because I think that the case stands or falls on that. So this is Sean Paul Reyes's Long Island Audit's response in opposition to defendant's motion to dismiss. Hey, Eddie, thank you. So this is his opposition to the motion to dismiss, and I'm only going to look at a specific part of it, because I think it all falls on this subsection C, defendant's absolute privilege / official duty theory is premature and fact-bound. He says Florida affords absolute privilege to public officials, and just I'm assuming everybody can hear me. If you can't hear me, let me know now so that I don't do another stream where the first half of it is dead silence and I have to re-say everything again. It is very cold out here today, so I'm not planning on staying out here forever. So if I could just get someone in chat just to let me know, one of you fine fellas, that you can hear me. Or I guess I could just start playing it on. Good morning, good evening, good afternoon. All right, so I can hear it on my side and you guys say that we're good. All right, perfect. So he says Florida affords absolute privilege to public officials only for statements made in the course of performing official duties. He's really gonna have to address Castro versus Stoddard. And he has a citation from '66, and you might notice that that is a fairly old citation. You would think that he would come up with a much more recent case that casts some doubt onto Castro versus Stoddard. He says whether the mayor's Facebook post responding to a journalist's criticism was within the scope of official duties is a fact question unsuited for a motion to dismiss, particularly where the complaint alleges defendant acted personally in publishing the statements and sues him individually. Well, kind of, but that is not really a fact question, because if you go back to the complaint, the way that he was acting, him publishing it in his personal or public stance, is something that the court, I think, should be able to determine. First of all, it is on the official Mayor Paul Sidney Alfrey Facebook page, a government-associated platform he uses to communicate with the public. That makes it sound like it's going to be official because it's on the official Facebook page, and this is according to the complaint. It's a government-associated platform he uses to communicate with the public. And then I'm going to skip down rapidly to the bottom and scroll up a little bit. So you'll see that he wrote Mayor Paul Alfrey, and he copied in the city attorney. Now, if he copied in the city attorney, that makes it think it's official. And he's also writing that you published on your official Facebook page concerning my appearance at the Melbourne City Council meeting. So this is a communication. Bazinga, he actually did say the name. He actually did mention Reyes, I believe. And we can double check that. And well, he identified him sufficiently that it's aware of who he is. I thought he mentioned them specifically. Maybe I'm misremembering it. In which case, I owe you an apology. Well, that's a good point. That is a very good point. So, mea culpa. I don't watch R.C. Randall. I'm sorry. I have no idea what you're talking about. And I would tell you to send it to me on Discord, but well, you can't. Oh, that's where I saw the name. Okay. But you're right. You're right. Does it say it somewhere in this that I'm going to miss? Did it say it in the police report? Interesting. Well, that's going to be another hurdle that Reyes will have to jump through. But but anywho, back to where we were. So he's contacting the city attorney. The post was, according to Reyes, and this is part of the complaint. This is attached to the complaint, so it's part of the complaint, and the judge can consider it. The post was on the official Facebook page. He copied in the city attorney, and he made it known that he was copying the city attorney. He sends this to Mayor Paul Alfrey. That sounds like he is treating it as an official communication from the mayoral office, and then he starts off with Mayor Alfrey. So this does appear, from the way that Reyes is treating it, that it was an official statement on the official mayor's Facebook page that is directly associated with it is a what do you call it? A government associated platform. So I don't know that the court is going to need more information in order to make this decision. I'm not saying that the court is going to grant the motion to dismiss. The court may allow this farce to continue a little bit longer. Um, the court may allow some discovery, but there's enough there on its own. And the defendant stating that the mayor was acting personally in publishing the statements isn't isn't a that's not a basic fact. That is an ultimate fact. That's something that you would have to show all the facts of to show that he was acting personally. You can't just say like, for example, that so and so did this with malice, right? You can't just say that. You have to show the things they did that would allow the court to come to the conclusion that what they did was with malice, because malice, like publishing something personally, is an ultimate fact. It's something that the decider of fact gets to decide that, based on all the other factual things, amounts to the thing that you're alleging. So it might be enough to withstand a motion to dismiss. It might be enough to withstand a motion to dismiss, but it is not necessarily, because all the court can look at all of the other facts that are alleged in the complaint and come to the rational conclusion, the obvious conclusion to me, that the mayor was using the official mayor page on Facebook to comment about city-related issues, i.e., the disruption at city council meetings and how the rules are going to be enforced at city council meetings. I don't know I don't know what facts that Reyes could allege that would lead a finder of fact to any other conclusion than this is the mayor acting like the mayor on the mayor's official webpage, talking about things that are of interest to the mayor and the citizens of the city. And again, he really needs to draw a distinction between Castro versus Stoddard in this case. Would this have to do with intent? No, no. It's the content of the post that's important. Like if the mayor got up on his official mayor page and he said, the the sushi at the 76 station on the corner of 5th and A Street is nasty, and the owners don't wipe their butts when they finish pooping, and they don't wash their hands, and then they make the gas station sushi by hand, and it's terrible for you and you should avoid it. Then you might be able to argue that that's him making a statement in his personal capacity, because while I guess, well, especially if the station is outside of the city limits, you have a really hard time saying that he's doing that in his official capacity. But if you remember in DeCastro versus Stoddard, excuse me, in Castro versus Stoddard, the mayor in that particular case was talking about about I believe it was the police chief and the police chief's alleged corruption, and that directly relates to what the citizens would want to know about. So the court would look at what was actually said. So just because the defendant made an ultimate statement of fact like that doesn't mean the court has to treat that as true. The court has to take the plain statements of fact, like on this date at this time this person did this, on this date this time this person did this. So like again, another example, if you say he assaulted me, well that's a conclusion. That's an ultimate fact that the court is going to be looking for you to prove at the time of trial. But if you say at this date at this time he hit me in the face, well that's the underlying facts. That's what the court is going to decide whether or not he was personally publishing the statements. He said the MTD's reliance on its own exhibits and characterizations, i.e. the post was on an official page and hence official duty speech, asked the court to go beyond the four corners and draw defendant favorable inferences. Well, as you can see, I showed you the complaint. This is the complaint. This is Sean Paul Reyes, Paul Sidney Alfrey complaint for defamation. And in the complaint, he states it's the official Mayor Paul Sidney Alfrey Facebook page, a government subsidized platform he uses to communicate with the public. That is literally in the complaint. So, I mean, I'm not seeing any real signs of success here. And again, I can't predict what the court will do, because courts sometimes have different interpretations of the law and the facts than I do. But in my best estimation as a first-year California family law attorney, my best guess would be the court is going to look at this and say there's nothing here. Like, I can either do one of two things. I can give Reyes more opportunities to, I guess, amend his complaint or something. But I don't see any reason why the court at this point would not dismiss it with prejudice, simply because there's no way around this for Reyes. Like there are no facts that he's going to be able to discover that's going to make this thing that he characterizes as the official mayoral page into a non-official mayoral page. There's no facts that he's going to be able to find a discovery that would make the mayor talking about what happened at a city council meeting and saying how the rules are going to be enforced in a city council meeting, not about a city council meeting. So he's absolutely wrong here. The motion to dismiss, I don't even think the motion to dismiss had any exhibits, at least not in the version that I got. Yeah, there are no exhibits. So I don't know what he's talking about there. I don't know if this is Chat GPT writing this up for him or some other AI program. Well, yeah, Eddie. The court may also just look at it and say, well, even if this goes all the way to trial, I don't think a jury could find that this was defamation. But I don't think the court has to. I think the court can get rid of it just really easily on the absolute privilege. But again, so this whole thing about the reliance on their own exhibits, no, they didn't have any exhibits. They're relying on the characterizations. No, you literally said this, Reyes. Like maybe the pot's hitting a little hard, but no. He says even if the page is mayoral, your complaint said it was mayoral. Not every public-facing post is an official act. That may be true, but in this case, it was the mayor talking about an issue at a city council meeting and how he was going to enforce the rules. Florida courts analyzed content, function, audience, and the context to determine whether the speaker was performing a governmental duty. Policy announcement. This was literally a policy announcement. It was literally a policy announcement and law enforcement notice. It was literally saying the policy that they're not getting rid of your First Amendment rights. Bloop, bloop, bloop. So he says his First Amendment rights were violated and that the Melbourne is denying free speech. He says that's untrue. That's policy. He says he was removed from our city council meeting for exposing a corrupt mayor. This is misleading rhetoric designed to grab headlines. In fact, our council rules, see, he's talking about the rules, clearly state do not address the mayor or council members individually. Despite this, blah, 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 when his time expired. So he's talking about a city council meeting. And then he finishes it with, I want to be clear, exclamation mark. His free speech was not denied, and our meeting rules were followed and enforced fairly. The harassment and death threats from him and his followers are unacceptable and will not be tolerated against me and my family, nor our public safety professionals, and there's a police report. So this is a policy announcement and law enforcement notice all rolled up into one. So if your examples, Reyes, of whether or not the speaker was performing a governmental duty, if those are policy announcement and law enforcement notice, bada boom, bada bing. Like, I shudder to think how you thought that this was a good argument. Versus engaging in public relations or personal defense of reputation, the latter not cloaked in absolute privilege. C. McNair, limiting absolute privilege to acts in execution of public or of official duties. Well, so unfortunately for him, again, McNair was, first of all, a case where they found that the absolute privilege applied. That's number one. But number two, McNair didn't involve anything like this particular Facebook post where someone is talking about a disruption in a city council meeting, and they're not talking about First Amendment and enforcement of city council rules and things like that, and what those council rules are. He says the MTD cited authority, DeCastro versus Stoddard, recognizes the same limitation. It does not convert all speech by an office holder on a public page into absolutely privileged speech. He says, at a minimum, the issue is for summary judgment after discovery, not dismissal. No. So in Castro versus Stoddard, that was done on summary judgment. So summary judgment is different than a motion to dismiss. Summary judgment can be done pretty much any time, but generally speaking, it's done after discovery because summary judgment is done where you have you identify all of the undisputed facts. And then all of the disputed facts you take as the non-moving party would have them. So if you're the moving party, you want to file the motion for summary judgment, you have to identify all the facts that both sides agree are true. And then every other fact you have to take as true, the other side's version. And then if all of those facts, the facts that are mutually agreed to and the facts that the other party agrees and the other party says are true, even if you don't say they're true, if all of those facts indicate that as a matter of law you win, then you win. But if every allegation made in the complaint are true, and the court can look at the exhibits to the complaint because those are attached to the complaint, they're a part of it. But even just the language in the complaint, if taken as true, they win. They don't need to figure out any other facts. The reason why you get the summary judgment is because you aren't able to show on the face of the complaint that all the facts taken as true are mean that the defense wins. So you don't. There's no rule that I'm aware of that says that you have to wait until discovery is done. There's no, it's because this is a matter of law, because this would be a ruling on a matter of law, not on a not on a fact-based finding. The court doesn't have to find any facts. The court just looks at the complaint, assumes everything in there is true. All the base facts are true, not the conclusions, not the ultimate facts, but the base facts as pled are true. And if they're true, then there you go. And in this case, uh, while the question of whether or not the page is official, it's the official Mayor Paul Alfie page. The defense filing the motion, they're not contesting that. So there you go. Uh, that it was government associated. The defense isn't contesting that. So there you go. Like they're saying, yeah, okay. So take all his facts as true. It's official government website or official government Facebook page. It's government associated. They're go for it. Go for it. Look at what he's talking about. He's talking about a city hall meeting. That is a government interest. City hall meetings are a government interest. Out of town people saying that the city hall and the mayor are denying people their First Amendment rights is a government interest. There's just no way around it. There's just no way around it. He says further publicly available Facebook quote page transparency end quote data confirms that the page titled Melbourne Mayor Paul Alfrey is a political or campaign page, not a City of Melbourne official page. Well, now who's trying to go outside of the complaint, Mr. Reyes? Now who's trying to go out of it? So it's a political page. Huh, that's weird. It's a political page for Mayor Paul Alfrey. Huh, well, that totally shuts it down. Facebook lists the category as political organization. It shows the page was originally created in 2020 as Paul Alfie for Mayor campaign and later renamed Mayor Paul Alfrey on November 27, 2020. There's no indication of city management, archiving, or IT ownership. Well, no shit. It's a Facebook page, homie. It's the mayor's Facebook page that you called the official government-associated Facebook page. The evidence, he says, strongly suggests plaintiff's allegation the defendant's post was made personally and not in any official capacity, defeating the foundation of defendant's absolute privilege claim. Well, the mayor in Castro versus Stoddard had a blogspot page that was his page that wasn't the city's page at all, but it was the mayor's page. The mayor's page. That's all it was. The mayor made it. The mayor made that blog spot, and the mayor talked about the stuff as a mayor that was important to him on it. So you have to distinguish at this point Stoddard versus this case. And you didn't. You absolutely didn't. You shit the bed, and that's it. You shit the bed. All right, we're going to do one more. And I'm going to leave it up to you guys. So we could do a one in chat for Earl Warden. I know he's kind of old news. He did file a motion for en banc hearing that I thought was well written. We can go over that. So one in chat for Warden or two in chat for Common Joe. Now, I don't think Common Joe is going to get it, but Common Joe is a fucking character. He's a sovereign citizen. He used to go by ethics instead. He used to be all tightly bound up with Springer. James Freeman. And he was James Freeman's legal guru before James Freeman actually got an actual attorney to tell him what the law is. Not that the attorney's necessarily much of a step up. So one in chat for Earl Warden or two in chat for Common Joe. I see 3 twos. All right. That's enough for me. We've got a small audience, so that's enough for me. So first thing is that the court, after the last hearing, the court had was so sick of Joe's shit, was just so sick of Joe's shit, that the court, sua sponte, not even in response to a motion, recused itself and said, I'm fucking done with this dude. I'm giving this over to another judge. And that, to me, is fucking hilarious. You know, you know, that it's bad. So we're going to listen to the hearing where he's trying to argue to use ChatGPT as his attorney. This trial was originally set, I think, for November, and now it's set in December, like December 17th. This is on the dog bite case. He has a couple, like driving without plate. He has a driving without plates and like suspended license or something like that also. All right, so I'm going to start playing this. Let me know if you can't hear it. There's nothing on the screen, I don't think.
Mr. Pierce, I'm assuming because you're here by yourself, you have not obtained any counsel, attorney?
Can you guys hear that before I go much further? Court just asked him if he had found an attorney yet. So there is a process, by the way. There is a process in uh, the state of Missouri to get a public defender. They do screen you for income. So you have to fill out a piece of paper that states your income. And oh, you hear it good. Thank you, Eddie. You have to fill out a paper that states your income and assets and things like that. And then you turn it in. And then if you qualify, you get a public defender assigned to you. So I do want to make that clear. If you don't qualify for it, or if you just, I don't know, shit the bed and don't even do the steps you have to do to ask for one, well, then either you're representing yourself, or uh, you hire an attorney out of your own dollary dues. And you might not like that, but that's the way it is. Now, one other thing that I do want to mention is that you can get a public defender to act as like advice counsel, advisory counsel, sometimes called elbow counsel, where essentially they just sit there and they're ready to take over for you if for whatever reason you decide you can no longer continue, or if the court decides you can no longer continue. They can take over for you, and they're there to like answer questions about, like if you have a legal question, like, hey, what kind of objection can I make to this, or uh, you know, what statute do I have to look at to do X, Y, or Z, right? This is something that I think didn't we see elbow counsel at least for a while in Myers? Yeah, we did. So that is available in Missouri. So, but remember that the trick to this is, I just want to remind everybody that the trick to this is that if for some reason you're no longer able to continue as the pro se attorney, if you're no longer able to continue, either because you don't want to continue or because the court won't let you continue, that attorney steps in and takes over. That is what happens. So now, additionally, it is my best guess is that if you are unable and unwilling, let's say unable to represent yourself, you can't abide by the rules, you can't keep from interrupting the judge and the witnesses, etc., and you're trying to proceed pro se, the court may order an attorney to represent you. I, I, I don't know if that happens. That would be a rare enough thing. I mean, most people are smart enough that at a certain point they realize that they can't do it, or they realize they need to actually abide by the rules, and or at least close enough to the rules that that they can muddle through it, or they decide to get an attorney. But I just so Eddie, pro per is the same thing as pro se. Uh, in propria personis is another way to say pro se. So California uses pro per a lot. Federal courts use pro se. Most courts use pro se, but California uses pro per, so you'll often find me saying pro per. But It means exactly the same thing.
Sir, I'm surprised to hear you mention the assistance of counsel issue mentioned without the obvious prior knowledge that battle back and forth that you and I have had over the last year of this issue, the assistance.
The battle back and forth that you and I have had. Well, there are no battles between you and a judge. You might throw out all the shit you want, but you're arguing with the guy who makes all the rules and controls everything. You're not in a battle. You ask the judge for things and he says yes or no. That's it. That's the battle.
Of counsel issue. There's a record on the court case net on April 2nd of me requesting assistance of counsel that I have secured, and they would like to appear via WebEx or the internet like everybody did in COVID for 2 or 3 years, and you denied that. I'm standing.
So the court would be right to deny that. First of all, in a trial, a lot of times there's documents exchanged. The attorney might want to have a sidebar with his client, just whisper something like I mean, it's very annoying. As an attorney, let me just say that having your client try to whisper to you while a trial is ongoing is about the most annoying and frustrating thing as possible. Because as the attorney, you have to listen to what's going on so that you can be making objections, so that you can hear what the testimony is, etc. Having your client whisper to you, just if you're ever in that situation, please, for your attorney's sake, please do not whisper to your attorney, especially while testimony is being given. It might not be important to you, or at least you might not think it's important to you, but it's very important to that attorney. Very important. But there are a lot of reasons. Um, if the judge wants to have a sidebar with the attorneys, like have the attorneys come up to the judge's bench, and so the judge can talk to them out of earshot of the uh, jury, things like that. I mean, there's a lot of reasons. I understand why people like Zoom so much, but just in my professional experience, law and motion hearings are fine for Zoom generally, but like depositions aren't as good on Zoom. Uh, Settlement conferences suck on Zoom. Mediation generally sucks on Zoom. And trials, like I would never want to do a trial by Zoom. Like there are so many things that as the attorney, I'm paying attention to at trial. I'm looking at the judge to see what the judge is thinking, or the jury. I'm keeping my eye on them, see what resonates, see what they like, see what they don't like. And if they like a particular thing, then I'll push more towards it. If I see them reacting negatively to the thing, I'll move away from it. And you can't do that by Zoom. There's a lot of little things that go on, and you can't hear everything by Zoom. So, if the if the other side is whispering loudly to their attorney about, you know, uh, what do I do if they ask me about X? Well, I'm going to be damn sure I'm going to ask them about X, right? Uh, Eddie asks, have I ever been involved in arbitration? Yeah, I've had to do arbitrations before. I've got a construction arbitration coming up next year. That's not fun. I have two arbitrations currently going on right now. So yes, I have been involved in arbitration. Is arbitration private? Yeah, that's one of the many reasons why a lot of big companies will have in their contracts that all the disputes are done through arbitration. They'll tell you it's because it's cheaper and faster. It is not always cheaper. It's not always faster, and it's rarely cheaper. Because you're still paying an attorney. You still do all the things. Like there's still discovery. There's still all the stuff in arbitration. But you're paying the judge on top of it, which you wouldn't be doing in in just regular state court. Um, but the big draw of it is for those companies is that arbitration is not they're not public records. So you could go on to, like in California, you could go on to a county court's website, and generally speaking, you could pull up all the records, all the documents filed, or almost all the documents filed in a civil action, like a lawsuit, like a construction lawsuit, just for shits and grins. Um, But an arbitration, nobody will ever know. So big companies love arbitration. I think it was legislation, the Federal Arbitration Act and like California's Arbitration Act. I think those were both pushed through by big corporations so that they could hide all of the negative bullshit. And like for example, Kaiser. If you have Kaiser as your healthcare provider, Kaiser has a mandatory arbitration agreement in their contract with you. So if you want to sue Kaiser, you have to file a arbitration notice with them. And that's why you won't find a lot of lawsuits against Kaiser for the frankly terrible uh, job that they appear to do, at least in my experience as a plaintiff's lawyer in MedMal. Uh, you won't see that. And there's no way that anybody would know how often their doctors get sued for MedMal because it all has to go through arbitration. Another thing is that companies like Kaiser, for example, who get sued fairly regularly for medical malpractice, at least in my experience, I don't have the numbers. Nobody has the numbers because it's private, because it goes to arbitration. But their attorneys all know the judge, all know the arbitration judges. They all know like, and those arbitration judges are running a business. Now, I'm not trying to cast aspersions on them, but because generally speaking, each side gets to pick, like they normally do like a lottery system where each side numbers like the judges one through, like let's say the arbitration company offers 10 judges. Each side will number the judges 1 through 10 from first pick to last pick, right? And then the judge with the lowest number is the one that's picked. And if there's a tie or a three-way tie, then they'll like basically do the lottery again, essentially. So so these judges, they get paid by for the cases that they do. Like a lot of times they're retired superior court judges and things like that, but they don't get paid if they don't work. And so they know, and this is conspiracy theory, John talking. They know that if they find for the defendant more, then they're going to get a lower ranking from Kaiser. And if they find for Kaiser more, they'll get a higher ranking for Kaiser. And they know that they're going to get the same attorneys over and over again from Kaiser. So it's in the judge's financial best interest, sadly enough, that they find against Kaiser. I mean, I don't take Kaiser Med Mals anymore because like it's so fucking stacked. Like it's insane. It's insanely stacked. The judges, I mean, unless you have a stellar case with stellar experts and they have to rely on nonsense, like you're gonna lose. Like you're gonna lose because I mean it's just stacked against you. It's stacked against the patient, and that's one of the reasons why I am against, one of the many reasons why I'm against arbitration, is because at least at state court that judge is going to make what that judge makes regardless of how he rules in the case. That judge is going to have people coming in front of him no matter what. His income isn't at stake based on the rulings that he makes. So I'm a big fan. We've gotten way off field, but I thought it was an interesting topic. So thank you, Eddie. We've gotten far afield from the nonsense of Common Joe. We're only 35 seconds in.
Here without the assistance of counsel. I have a right to assistance of counsel, but enjoy no assistance of counsel. In fact, part of the motions that I brought here today, something I just filed not 20 minutes ago, was something that I would like.
Here's a good rule, by the way. You can never, maybe in federal court, but with an asterisk next to it, almost never file a motion in the morning and expect the judge to rule on it in the afternoon. Because generally speaking, opposing counsel has to have an opportunity to respond to it. This is the whole due process kind of thing, notice and an opportunity to be heard. Almost without exception, if you file a motion in an ongoing case, unless it's like an emergency motion, uh, it, it's not going to get heard that afternoon.
The ability to stand in court order where I can record all audio inside of a courtroom because I'm having to use ChatGPT as assistance of counsel because I'm here facing all these charges in this system with no assistance of counsel, no law degree, no bar member helping me whatsoever. This has been an ongoing issue. That's why I'm surprised to hear you mention it so casually.
I'm not mentioning it.
He's just like, hey, you don't have an attorney yet. You probably need to get an attorney. Oh, I'm surprised you're mentioning it so casually. Well, like the judge isn't going to jail, homie. The judge isn't the one going to jail if he loses. You're going to jail. It would behoove you because you're so retarded. Like you don't know shit from fuck. You need an attorney. You really do. I mean, I don't know how good your case is or how bad your case is, but you fucking need an attorney.
Anything casually. The answer to my question is you don't have an attorney. I've given you a lot of time to get that done.
I have an attorney, sir.
There were 2 lawyers that
So one of the things that so normally you have to get a waiver in Missouri. My understanding, again, I don't practice law in Missouri, but you have to get a waiver signed by the defendant saying that he understands that he should get a lawyer and he's choosing to represent himself anyway. But there are exceptions to that. And one of the exceptions to that is if the lawyer doesn't, or if the defendant doesn't take any action to get an attorney, the judge can take failure to get an attorney as essentially implied consent. Basically, they're not going to hold this case up forever and walk away from it, like basically walk away from it. 20 years later, Common Joe still doesn't have an attorney. Well, shit, what do we do? So if Common Joe doesn't get an attorney at some point in time, the court will not continue the trial again, and the court will say, hey, you had ample opportunity to do something, and you didn't fucking do it, so, the ship has sailed, son.
even volunteered their services. I don't know whether you talked to them or not, but
Well, sir,
and I understand the difficulty in that.
in open court.
So I don't know if you heard it, but the judge said the last time we were here, 2 attorneys, not one, but 2 attorneys in open court volunteered their services, and you rejected them. Huh. So what's the problem?
I'm not going to go back and refresh the prior ruling about appearing by WebEx. I don't like to do that, especially for a jury trial, and that's why I denied those motions.
So you're denying me the right to assistance of counsel,
No,
sir?
not at all.
So you're denying me the right to assistance of counsel. No, you could go out and hire an attorney. There's nothing preventing you from going out and hiring an attorney. Maybe your funds are, but that's a you problem. And if you don't have enough funds to do it, well, maybe you should fill out the fucking form to ask for a public defender. I mean, what do I know though? I'm just a California first-year family law attorney.
The court has given you ample time.
Sir,
The court has just made a finding on the record that the court has given him ample time.
John, second thing.
Sir, I explained last time. If I can just
Let me finish. You keep interrupting me, and that's not a good idea. Sir, what's your
I'm
name?
trying to.
What's the last name?
Campos, C-A-N-P-O-S.
Line 8. Okay, just sit tight. Yes, Mr. Pierce, the last time we were here, you had filed 4 motions, 5 motions. I have those noticed up for today. I think we should take those up because you wanted to be heard. Now, a couple of them, I reviewed them briefly this morning. Some of them regarding...
Sir, before we move on to the motions, can I just please finalize our addressing of the lawyer issue?
The lawyer issue was the court confirming that you don't currently have a lawyer. That was the lawyer issue. It's done.
Sure.
Okay, because you mentioned the last hearing, and I just want to state on the record that last hearing, yes, I agree. 2 lawyers randomly spoke up in the middle of the hearing and offered their services to me for quote-unquote whatever I'd be willing to pay. I then asked them, great.
For whatever you'd be willing to pay. Oh my God, those are two fine gentlemen for whatever you'd be willing to pay. Boy howdy. Like lawyers in Missouri must be rich because, whew, or maybe those lawyers just really need the money. I don't know.
And I would say I would accept the assistance of this counsel if they are not required to, quote unquote, represent me, which means completely dominate everything about the case according to this court. Meaning, if you wanted to use your power to hypothetically have me removed because you didn't like what I was saying, you could address the attorney who's, quote unquote, representing me, and to this courtroom, that would be me.
Uh huh. So, yes, there is no way you're going to get counsel. And counsel, again, has been determined to be like licensed practicing attorneys. That is what counsel is. Um, and they have to perform as a normal attorney would in your situation. And that's why you can appeal for ineffective assistance of counsel because there is a standard. There's a standard by which counsel has to operate. They have to be licensed. They have to be a practicing attorney for your area. And their performance has to be measured by the standard of what another attorney who practices law in that area would, could, or should have done in that situation. So that's the bar for what assistance of counsel is, because you're not just entitled to assistance of counsel, you're entitled to effective assistance of counsel. Not just anybody. Not you could get your retarded brother Bob, who does meth all day long, to come in and be your counsel. That's because obviously, if the court ever allowed that, which they wouldn't, but if the court ever allowed that, not only would your retarded brother Bob be practicing law without a license, but it would be an automatic overturn on appeal because you did not have effective assistance of counsel.
And you could find guilty and proceed with all manner of abuses of power. And
It's not an abuse of power. And even if you continue pro per, if you're an asshat, the court may, at some point in time, remove you from the courtroom and appoint an attorney and continue the trial to another day to give that attorney time to get the facts and the law down and do it without you. The court can still do that, even if you don't have an attorney. The court has that power. Like if you think most of these sovereign citizens tactics are, as far as I can tell, are just delay mechanisms. They're just trying to delay, cause so much trouble that eventually someone's going to get tired of them and just be like, fuck it, I don't even care anymore. But the system is designed to get to a verdict at some point in time. Somebody's going to say guilty or not guilty at some point in time, and you can only delay so far. So, yeah,
I would be out in the hallway completely unable to defend myself. And it's only because of that rule that I don't want an attorney to, quote
out in the hallway, you'd probably be in jail if they removed you.
unquote, represent me. If they want to be standby counsel or whatever term this court, with all the power it has, uses to say, hey, they can serve as assistants of counsel, like it says in the Bill of Rights.
It doesn't say they can serve as assistants of counsel. You are entitled to effective assistance of counsel, and there is a definition for that. It has been defined. You can't just go back to the words on the page. You have to look at how they've been interpreted. Supreme Court wasn't Gideon versus Wainwright. There was a couple before then that dealt with the effective assistance of counsel, and the Supreme Court has determined what that means. And what that means is bar certified, practicing licensed attorney, however your state does it, maybe not bar certified, but maybe state certified, whatever, but a licensed practicing attorney in your area, and their performance has to be like at least the average for what a normal defense attorney would do.
Everybody here would be happy. I have shopped for, go on Google Maps and look for the 6 closest criminal defense lawyers to this building. I've called them all and I've got answers from them all, and they all will not take the case because they demand that they have full power of quote unquote representing me.
Full power of representing you. Well, so there's 6, and then plus the 2 in open court. So that's 8 attorneys. He's talked to 8 attorneys. How many attorneys do you think are in his area? How many attorneys do you think are in his area? St. Charles, Missouri. Criminal defense attorney, St. Charles, MO. Go to maps. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. 14 on Google Maps. So he hasn't even talked to half of them yet. And that's just, oh, there's more. There's more. Oh gosh, there's more. Oh gosh. Look at all these attorneys. Look at all these attorneys. Oh gosh. So, yeah. I mean, you haven't really done a whole lot of work there, buddy.
Given the allegations of abuse of power that I've had in this entire proceeding over the past year, one could reasonably understand why I would not agree to such an...
What abuse of power? What court has found that there's been an abuse of power? Oh, it's your feelings? But it's really good to the guy who controls everything that goes on in that courtroom to tell him that he's abusing power. Because, well, why not just piss off the guy who's in control? Why not? Just stupid.
an agreement. That's the issue on the lawyer. I still stand here without assistance of counsel. I have ChatGPT I would love to use for assistance of counsel, and I would consider that and sign documentation that fulfills my assistance of counsel. But in order to use that, I need a laptop capability in here, and I need it to be able to audio record because it can hear, the technology is such today that it can hear a voice, immediately live transcribe it into written words, and then when you're finished speaking, it will text out a recommendation of what I could say. I will then choose whether or not to say that and respond accordingly. Now, I know this is the first time ever technology being proposed in a courtroom, and I'm proud to be the person to make it, and I'm happy this is being recorded for the record. I am standing here without assistance of counsel. I humbly and respectfully request that ChatGPT be allowed to be used as my assistant.
I humbly and respectfully request, after accusing the court of abusing its power, which is a prideful statement to make, and certainly a disrespectful one, I humbly and respectfully ask. It's like, when someone says, with all due respect, you're a real son of a bitch. Anytime anybody says, like, with all due respect, there's not going to be any fucking respect coming. Well, his humbly and respectfully is neither humble nor respectful.
Assistance of counsel, and that the court provide the technology and hardware in this building to do so in the future. Thank you for listening.
Appreciate it. Does the state have any response to?
Yeah, Judge, I mean, there's so many problems.
Eddie asks, so this hearing is an hour and 17 minutes long and no contempt or warning of contempt. I've heard about the first 15-ish minutes of it, maybe 20. And no, I have not heard contempt, but maybe. Will you also be live streaming on the computer? Well, I don't know. He asked them to provide the computer, which I think is kind of ballsy. I'm surprised he wouldn't have provided his own computer. But I mean, if you're gonna ask, you might as well ask for Mars. Maybe they'll give you the moon, right? So maybe there's contempt or a warning of contempt in here. I don't know. But after this hearing, the judge did recuse himself. So
Problems with the AI in the legal world right now. It's not trustworthy. It makes up, false case law, goes off of false rules, I don't think it should be authorized for the courtroom. I don't think it's ever been done. I don't think it should be done on this case. I mean, that's really all I can say, but
Okay.
May I allow a response to?
You finished, Mr. Murphy?
for a minute.
Go ahead, Mr. Pierce.
And I was really irritated with the prosecution, because the prosecution should have just said, he's entitled to effective assistance of counsel. Counsel has to be a licensed practicing attorney. Like, what is he charged with? He killed a dog. The charges, I don't know if it was cruelty to animals or something, but he shot a dog. He said the dog was attacking him. The owner said the dog was bringing the ball so that he could play with it. I don't know. Apparently apparently it was recorded on like a Ring camera or something. The incident. I haven't seen that footage, so I'm not saying that he did it or he didn't do it. I don't know. I just know that he just is fucking terrible at practicing law. He's just terrible at it. The plates. I think it's plates and no proof of insurance, or plates and suspended license or something. Those are separate infractions that he's. This case is he could actually get it like a year, and the other ones they're done separately, separate judge, separate prosecutor, so they're entirely different. Was it a pit bull? I don't know. I love pit bulls. I've only had pit bulls that were good dogs, so I know there's a lot of stereotypes about pit bulls, and I'm not saying that that's wrong. Statistics are statistics, uh, but I do wonder strongly if it's the owners that are the problem and not the pit bulls themselves. Because again, I know all the stereotypes, and they enrage me every time because I don't have a pit bull. Well, I guess I do. I have a 15-year-old pit bull right now, which I don't really count because it was my sister's dog, and I'm just giving it a place to live until he passes. Um, but best dogs I've ever had, the best dogs I've ever dealt with have been pit bulls. I love pit bulls, and I guess that makes me a terrible person too. I guess that's probably anti-Semitic to like pit bulls or something. I don't know.
Lawyers have been caught by the hundreds and thousands by judges in this country in the last couple of years using large language model programs in the performance of their duty.
Yeah, they've been caught and in some instances sanctioned for doing that.
Those who have not been caught have not been caught.
Well, again, there's a right way and a wrong way to use Chat GPT and similar things. And if you use it as a starting point for research, and I'm being specific there, a starting point for research, that's fine. But you have to actually do the research. You, the attorney, have to actually do the research. So you could say, pull up all the cases on this particular issue, and then you read the cases. So, you know, yes, there's like Westlaw. I think they sell an AI that is designed and programmed for attorneys, specifically for attorneys. Apparently, allegedly. So because ChatGPT and other things, because they're not specific for attorneys, they often paraphrase things and they don't directly cite things. The attorney AI programs, from what I am told, I don't use them. They actually pull direct citations because you don't have to worry about copyright. It like looking at legal documents, like you have to worry about copyright when you're looking through like literary works and things like that. So
This trend of, and may I correct Mr. Murphy, I am proposing the use of a large language model. This is an LLM. This is not AI. This is not artificial intelligence whatsoever, even if it claims to be so. Large language models simply predict the next word that makes logical sense according to the ongoing conversation.
He says it's AI.
I immediately, this year, as soon as ChatGPT came available, I immediately started paying it money and using it as assistance of counsel.
No one
All
fucking
of the
cares.
motions that have been filed in the CaseNet under my name in this case were heavily influenced by
heavily influenced by ChatGPT. Uh, Let me just say that I have read several of his motions, and they are universally shit. They are universally pure shit. Like, they're just garbage. They're just garbage. Fucking Mets, Rogue Nation writes better motions than ChatGPT apparently. But again, ChatGPT is the best ChatGPT can be is when someone who knows what they're talking about, who knows what they want, who knows how to ask for it, who knows what they're looking for, who knows what they want, who knows how to ask for it, like knows the language to use, the terms of art to use to get the best possible response from ChatGPT. Yeah, uh, John, the lab man, says he doesn't know how to ask the questions. That's entirely true. Pro se litigants don't know the law. If you know the law, you could ask the right question. You could phrase the question in the right way to get the right response, or at least the most correct response that ChatGPT can give. But again, it's like having someone who knows, like, for reasons that I don't know, I was given a workers' comp case to do, and immediately my heart sank. I did a little bit of work on one or two workers' comp cases in the past, but it was just a little bit of work. But this was handed to me like, here, you do this. And I am an attorney. I practice the law. I have practiced civil, criminal, family, probate. I've done a lot of law in a lot of different areas, and I knew going into this workers' comp that I don't know what I need to look up to know what I need to look up, if that makes sense. I don't know the questions to ask. And it took a lot of hours of me poking around, reading things, oh, that's not really what I need. I need to refine my search this way. Okay, that's closer, but it's still not what I need. And then, okay, so this is what I need to ask. It took me a long time to figure out what I needed to ask in order to ask the question that I need the answer to, if that makes sense. So handing a tool like that to someone, it's like turning a pro se litigant loose in a law library. You wouldn't know what the fuck to do. I've been in law libraries where there are pro se's in there, and they spend a lot of times asking the law librarian, what do I do? The law librarian can't practice the law in there, but they could give them like advice. Well, maybe you should start looking here or there, but they don't know. Like, they don't know the questions to ask to get the answers they need to figure out the questions that they need the answers to.
ChatGPT. So whether or not the court wants to recognize it or say, oh, it's new technology, we are not going to do it, I have been using it. I am claiming for a fact, under penalty of perjury, that I have been using it all this.
Nobody gives a fuck if you've been using it. There is a difference between you going home and doing your own research, however the fuck you want to do it, writing your shit motions for the court to consider. There's a difference between that and real time trying to conduct a trial. Real time how to conduct a trial. Like, good luck. You can't go through and double check what ChatGPT is spitting out. But again, you're running face first into the problem that ChatGPT is not a licensed practicing attorney in your area.
Entire time, and that it has been extraordinarily effective. The claims that Mr. Murphy makes about it using fake case and I understand why he would say that. And because I've trained myself so well with the use of this program, and it has trained itself.
I've trained myself so well with the use of the program. The program that I don't know the right questions to ask, the program that's going to give me answers that I don't know if they're right or wrong, has trained me. It's literally the blind leading the blind. Like, this is literally the blind leading the blind, because you don't know if what it's telling you is right or not. He's had 4 motions moot already. Interesting.
To me, I can instantly recognize anytime it does any of these tactics that he's worried about, They don't even they don't come out of my mouth because I'm obviously the final decision maker on what I say and what it doesn't. I'm perfectly well educated on how it operates and how it can make things up.
Yeah, but you're not perfectly educated on the law. And that's the problem. That, and it's also not a licensed practicing lawyer.
Believe you me, it's my precious time, all these hours that I've used in preparing myself in my defense for this case, and another, by the way. So I am simply stating that I would like to use something that is available to me and the court could provide it easily. I am facing up to a year in jail for a dog attack, and I've claimed all along this dog did not have a ball in its mouth.
Judge, can I respond?
Sure.
Not only would he be using that in the courtroom during trial or whatever else, that app is recording everything that's going on here. We don't know what data it's saving. We don't know where all that's going to go after this. And just it being practical here in the courtroom, are we going to have to wait till it absorbs all the information?
No.
Spits out whatever it processes and tells him to say? It's just not efficient for the courtroom. He's had ample opportunity to get an attorney.
I just said they won't accept the case.
Okay. Okay, so
I just said they would accept the case under your terms. They won't accept the case under your terms. And, you know, I've had situations where sovereign citizens have tried to retain me and other attorneys that I've worked with. And they're just not fun. They're just not fun to work with because you're the attorney and you know the law. And you've probably looked up the law and verified the law before you've done whatever it is you've done. And then you have the SovCit come and say, well, I actually want this, I want that. It doesn't work that way. That's not the way it works. You can't have that because that's not the way it works. Either you let me conduct your case or you conduct your case and I'll be relieved as counsel. You get your choice.
a couple of things before we get started on the motion. There's a couple of things you said, Mr. Pierce. You said you wanted the AI as an aid and as an attorney.
A large language model.
So that it can help you in your defense of this case.
Not AI, sir.
The whatever electronic
Yeah.
means you're intending to use. Those are not licensed attorneys. I'm not going to allow that in the courtroom. If you want to.
And see, I'm glad the judge picked up on it. I was frustrated. I was kind of live responding in my Discord. When I first watched this part of the video, and I was just fucking furious that prosecutor wasn't mentioning the fact that effective assistance of counsel requires a licensed attorney. Just furious. And I was so glad when the judge finally was like, yeah, actually, it needs to be an attorney there, brother. So,
Use that as your legal research. You can use whatever you need to use.
Sir, I'm not a licensed attorney.
And as far as attorneys go, it sounds like you have the means.
I think his attempted argument there when he said, I'm not a licensed attorney. Yeah, but you don't have to have a licensed attorney to represent yourself. Everyone has the right, with an asterisk by that, because there are certain cases where you don't have the right. But everybody has a right to represent themselves. Almost everybody has a right to represent themselves. And you don't have to be a licensed practicing attorney to represent yourself, but you do have to be a licensed practicing attorney to represent someone else. And people get that all confused all the time because, like, corporations, like a lot of times, like a corporation, like a small family-owned corporation will want to have the, dad represent the corporation, and you can't, you're not an attorney. Or in probate cases for conservatorships, the if there's a guardian ad litem that's been the court has allowed a guardian ad litem to be appointed, that's not an attorney. And so, so as soon as the conservatee has a guardian ad litem appointed, then there has to be an attorney appointed, because the guardian ad litem can speak for the conservator or proposed conservatee, but can't practice law for it. So the guardian ad litem can say things like, well, the conservatee, I want this, I want you to do this, I want you to do that for the conservatee. But then it's the attorney who has to go ahead and make the motions or do the things on the guardian ad litem's behalf, on behalf of the proposed, or on the proposed conservatee, if that makes sense. So it's the practice of law that requires an attorney. And if you have ChatGPT in there essentially practicing law, well, no, it's got to be an attorney.
To hire an attorney, and
I do not.
find one that would only do this as a reference or guide.
I do not have money to hire an.
Excuse me.
I'm sorry.
I didn't interrupt you.
You're correct. I'm sorry.
So we're going to proceed with the motions today that have been filed, and you've been had those on file. What I want to know is, beginning with the first one that I have written down, motion to compel exculpatory evidence, that's your motion, Mr. Pierce.
Sir, I don't have money to hire a lawyer. If I could hire a lawyer, because one would accept
That situation's been resolved. You're moving on.
my case, I don't have the money to pay them. Part of the motion I filed this morning is I would really like to have the $2,500 that I had to pay to get out of jail back to me. I have ties to this is written in the motion I filed this morning. I've been coming to every hearing for a year. I am no flight risk whatsoever. I have stated all along I am going to fight this to its conclusion and file a federal class action lawsuit at the end of it. I'm not going anywhere. I'm behind on rent. If you want me to hire an attorney, it would help if the government would give me back the $2,500 cash.
Well, I don't have that motion in front of me. If you say you filed it, and
I have a copy of it here.
No, I'm not going to take that up right now because he needs time to prepare and review that, and we don't have that on the agenda for today. Yes,
Judge, she's saying now that he
I think if I remember correctly, he was put in jail on a contempt because he walked out of a court hearing, right? He's like, I'm not a flight risk, but I think it was contempt because he was like, well, fuck it. If you guys aren't going to play the game the way I want to play it, I'm just leaving, and he fucking left. And I think that's why he got the contempt, and I think that $2,500 is basically securing him actually showing up and staying through the hearings. So I was like, I'm not a flight risk, bro. But you literally did. You walked out of the hearing, but you showed up, but you walked out. Oh, fucking stupid.
he can't afford an attorney. I mean, he could have an indigency hearing if you see that if the public defender could represent him. It sounds like he doesn't want to proceed on anything.
You're free to apply downstairs if you're...
Is he not listening to a word?
You're free to apply downstairs if you want that public defender. You say you don't have money. It's fucking crazy. He's like, he will come up with any excuse to use ChatGPT and not an attorney. They're like, oh, you don't have enough money? Go downstairs. Apply for the public defender. No, I can't do that. I can't find an attorney. There's 2 attorneys who stood up in court. No, they won't work. It's like, come on, dude. There is no solution that you would be satisfied with other than ChatGPT. It's fucking crazy. And sorry, you can throw your little tantrum, but you're not going to get ChatGPT.
What I'm saying,
Let's not,
I can't have a lawyer represent me, and you're saying you don't want to have ChatGPT because it's not a licensed lawyer. Sir, I'm not a licensed lawyer, and I'm defending myself alone without the assistance of counsel that is guaranteed to me in the Bill
Yeah, and it's all choices you're making.
of Rights.
I understand that.
I can't afford it, and none will accept it.
Is it in the Bill of Rights?
Many months.
They won't accept the case, and I don't have the money to pay.
They won't accept the case because it sounds like you want them with a condition.
That's right,
that they
Fifth
not
Amendment.
take
A
over.
condition that I've had countless other...
Lawyers don't want to do that.
I've had many lawyers working that way under me. With the judge's permission, they allowed them to work that way under me.
You're allowed to file whatever motion you filed, and if you did, then we'll take it up if it's filed in accordance with the Supreme Court rules. One of the motions you did file.
You're right, Patricia Fodor. I am not LIA. That is correct. If you scroll back to the beginning, that's when we covered LIA's opposition to the motion to dismiss.
File is a motion to compel discovery of exculpatory evidence / Brady request. Sir, that's your motion?
Sir, let's structure some organization. You're pulling out a random motion. Now I have 4 motions filed from July 7th, and I have 3
Let's structure this, Your Honor. Let's not do it the way you want to do it. Let's do it the way I want to do it, Your Honor.
motions that I filed on August 28th. I have hard copies of all of them here, and I'm wondering which one are you pulling out randomly and why? And I would further.
I'm pulling out the motion was filed August 25th, 2025, labeled motion to call recovery, a disclosure of exculpatory evidence.
Okay.
Parentheses, Brady report.
Allow me
Your
a
motion, sir. Go
allow
ahead.
me a moment to collect it.
Certainly.
This is the one you want to have.
Filed on August 25th.
Your Honor, I don't
Okay.
mean to interrupt, but while we're taking a short break while he gets his stuff in order, Mr. Campos is in for you.
That's what you can't put there, circle his date. Sir, that's on that memo that the officer's going to give you. You're free to go. Thank you.
Thank you, Judge. I apologize for the interruption.
All right, you ready, Mr. Pierce? You got it?
Yeah, I see the motion filed here, and the motion that carries precedent over all these motions is the verbal motion, and the motion to dismiss that I filed on July 7th. It's a motion to dismiss because of the state's improperly filed case.
Well, I'd like to take up the motion to compel disclosure of exculpatory evidence filed on August 25th so we can maintain some...
We're going to do it my way. We're not going to do it your way.
I appreciate you saying that, Judge. I respect it. I'm simply informing
I appreciate it and I respect it. But fuck you, Judge. We're going to do it my way.
you that the motion to dismiss all charges takes precedent because if it is granted, then this motion is all moot. It wouldn't matter at all. It's a complete waste of time to rule on it. We need to address motions that dismiss all charges entirely, get through those, and then go through motions that presume that the case is going to continue. And
Yeah, I think you do them in the order the judge wants to hear them.
I add really quickly, I find it really unfortunate that the court decided to schedule a pretrial conference and 2 days of a jury trial, knowing that this motions hearing was scheduled for today, knowing that several motions were to dismiss all charges. It seems
Because again, all these sovereign citizen things are just delay tactics. That's all they are, is just delay tactics. So, how could you set a trial? Well, because this has been ongoing for a long time. That's how. That's how we can set it for trial. This has been going on since like 2024. Like, that's how. We set it for trial because we don't know whether or not your motion to dismiss is going to be granted. So we get you on the calendar so that if your motion to dismiss is not granted, and since you say ChatGPT wrote it for you, my presumption is it will not be granted. That way we can keep moving forward because again, the state is going to get this thing to trial. And you can only drag your heels for so long and then you'll be at trial.
presumptive of the court to presume that everything's going to be dismissed, and they just go ahead and schedule these times and places without my input whatsoever.
Yeah, because the presumption is that a motion to dismiss will not be granted. That is the presumption. Because pretty much in every criminal case, the defense is going to file a motion to dismiss. Almost all the time. I have never been involved in a criminal case where there was not, no wait. Okay, there was one. But almost always you file a motion to dismiss. Almost always. Like, you never know. I mean, you can't hit a home run if you never take a swing at the ball. So you take a swing. Worst thing that happens is it gets denied.
However, what's going on convenient to my life. Do you see what I'm saying? You scheduled a trial with a motions hearing today with motions on the record to dismiss all charges. That in the courtroom of public opinion
You're not in a
would
courtroom of public
wildly
opinion.
succeed.
You're not in a courtroom of public opinion. You're in a court of law. So maybe you should figure out where the fuck you're at.
This is all foundationally built on the opinion of one woman and no other evidence.
Well, apparently there's a video too. So opinion of one woman, a video, a judge or a grand jury found that there was probable cause. And the state has also had the opinion that they have sufficient evidence to get a conviction. So, or else they wouldn't or shouldn't be bringing it.
whatsoever. I just got done reading the complete police report. You have a witness I've never heard of before who's claiming to actually have seen the shooting. This police report mentions a work truck by a neighbor that has video camera of the incident himself.
Let's argue the evidence at a motions hearing, you fucking retard.
And that they just need to get the video from the company.
Hold on, you're talking.
This is exculpatory evidence, sir.
Talking a lot here, and you need to slow down for a second. Your request is for the court to take up your motion to dismiss on July 7th. That's the one you want to take up first.
Yes, sir. I have it here in my hand.
All right. Mr. Murphy, you have the July 7th motion to dismiss for lack of credible evidence.
Wow. Wow. So the judge is being very kind. I am shocked. I didn't get this far, so I must have not made it 15 minutes in. But interesting. Interestinger and interestinger. What a nice judge. I don't think he realizes how nice this judge is.
No, this one is called a motion to strike and dismiss complaint and request for full finding of fact and conclusions of law. This is the one I filed initially, pretty much on day one, once this case really started.
Let me make sure I have. All right, filed on July 7th, labeled motion to strike / dismiss complaint and request for full finding of fact conclusion of law.
Yes, judges have seen this motion for 12 years straight, and I won a case on it that threatened me with a year in jail, and they admitted the prosecutor didn't have jurisdiction.
Mr. Pierce, let's
And they admitted the prosecutor didn't have jurisdiction?
Hilo, Hawaii, you can look up that case.
taking up the
It's in Hilo, Hawaii. You can look up that case. Okay, so you want the judge to look up the case from a completely different state where it was dismissed prior to trial. Okay. I don't know why the judge would care.
motion filed on July 7th, motion to strike, your motion. You
That
can
it-
proceed, Mr. Pierce.
Another judge has granted this motion.
Okay, Mr. Pierce, you may proceed.
What?
I would assume that that other judge, first of all, would have been in a different court case, in a different jurisdiction, with different facts and evidence in front of it, and a different complaint. Was it for a dog shooting? So probably a whole different, well, I mean, it's a different state, so they're going to be different charges with different elements. So, like, I don't even understand how this is relevant.
What do you want me to proceed with?
Your motion. I have the written file.
My motion stands on its own. The words
You
are...
wanted to speak to
Have you
the-
read the motion, sir?
You don't get to ask me questions. It's your motion. Do you want to add anything to your motion? Do you want me to take it up as it is?
You're a judge ruling on the motion with power, and you're saying you don't have to tell me if you've read it or not?
I've read everything.
You don't have to tell me if you've read it or not? Oh, you're a judge ruling on the motion with power. What a faggot.
Mr. Pierce.
You have read the motion.
Yes.
Okay, thank you for that
It's
answer.
your motion. Do you want to add anything to it? Do you want the motion to stand on the pleadings, or how do you-
For fear of my words being used to replace the words in the motion, and then you strike down my words, I will not add words to it. I will allow it to stand on its own, and I predict that you're going to not only deny it, but you're not going to give me grounds and reason for your denial.
What a douchebag.
You want it to stand on your own. Okay. Mr. Murphy, do you want to respond to the motion, if anything? This is the July 7th motion to
I
strike.
could just go briefly point by point if you want.
On this motion.
Let's do it.
This motion only, go ahead. If you have objections to it, why I should grant his request.
Yeah, Judge, this first argument here in paragraph 1, it says there's no case, crime, or cause of action. Well, actually, Judge, there's a charge of animal abuse that has been filed, and our office has filed charges, and part of his argument is that the basic elements of the case or cause of action is a violation of the legal right and loss or harm. Well, we have that here. We don't like
I'd object to the counsel restating...
I'm making my argument, Mr. Pierce.
You're restating
I
my...
have to go and make my argument.
You're misrepresenting my words.
You already talked. You said you
All
wanted
right,
to...
well, here's what we'll do, Mr. Pierce. I'm going to overrule your objection at this point, but I'll give you time to...
He can't lie about what I'm saying, right?
I'll give you time to
Okay.
respond.
Okay.
Go ahead, Mr. Murphy.
Yeah. Judge, we're alleging harm here. It's in our charges, in our information, that he committed animal abuse in his position. So, that's my point on that.
May I respond to that point then?
I don't think he's done.
Well,
When he's done, you
can I get a
respond.
pen and a paper so I can write down all these so I don't forget them? Do you have a pen and paper so I can write down all these points? If I'm going to be expected to remember them all.
You're representing yourself, you bring it.
Without the assistance of counsel, I'm not representing myself at all. I didn't agree to that at all.
Look, Mr.
Oh my God. Show up to a court hearing without a pen and paper and then blame it on that, not having the assistance of counsel, and then saying that you're not representing yourself. Well, who the fuck is representing you right now?
Mr. Pierce, if you want to write something down, you should have brought
So
paper
just
with you.
okay, then I can't even have a pen. The court won't even offer me a pen. Never mind assistance of counsel.
What a, just a, oh, he's arguing like a woman. Oh, yeah, just fucking man up, dude. Like, you got yourself in this position, fucking figure it out. The court won't even offer me a pen, let alone assistance of counsel. Just fucking, oh, I want to slap you.
How many you give him this pen?
Such easy request.
He already denied to make any argument in the beginning. He can't go back and respond.
Well, you can respond to anything that you bring. Go ahead.
Yes, I can.
Hold on.
I didn't teach you that in law school.
Come on.
Well, at least the prosecutor went to law school and no, the way it works is if you don't make any additional arguments, he gets to make his arguments against it, and then the court takes it. Now, the court is being very generous because you're pro se. But man, you're abusing it.
Okay, you're right.
His second point is that there's no corpus selecting, that there's no body. Well,
No corpus delicti? Oh my fucking God. Oh, no corpus delicti. Well, there's a body of the dog, first of all. Corpus delicti. And I may be misremembering this slightly from my law school days because I haven't had to deal with this because, well, it doesn't come up very often. But corpus delicti basically says that, like, you can't just convict someone on a admission of guilt of theirs. So let's say little Susie goes missing, and your retarded brother Bob, with his meth addiction, goes to the police station and says, "I killed Susie." Well, is that enough to get a conviction? No. What corpus delicti says is there has to be other evidence sufficient to back up the admission. So maybe they find sufficient blood to do it. Maybe they have to find the body itself, but they have to find sufficient other evidence to show that there actually was a murder. Because at the time that the retarded brother Bob goes in and says, "Yeah, I killed her," well, all they know is that Susie's missing, and so it's a corpus delicti, the body of the crime. It is the facts that show that a crime was actually committed, and you can't just rest on a statement.
Judge,
In other words, it's entirely inapplicable to this case because you've got the body of the dog, you've got eyewitness testimony saying that he shot the dog. He's even apparently admitted that he shot the dog. His whole defense is an affirmative defense of self-defense, essentially, however they phrase it for that. He says he was being attacked by the dog. So, like, there's a fucking dead dog. There's your corpus delicti, dude.
I believe you know what corpus delicti means, and it's just that.
Objection, can we define our terms? I would not like to agree to arbitrarily vague
It's in
stated
your
terms.
motion. It's
So
in the-
state it, sir.
Okay.
Don't
Because
restate it.
The corpus delicti is the body of crime itself. Virtually every American jurisdiction agrees it's an absolutely essential element of any crime and is consistent with the stated purpose of American governments. In every criminal trial, the prosecution must prove the corpus delicti from the body of the crime itself, the fact of injury, loss, or harm, and the existence of a criminal agency. Judge, that's all alleged in our information. Okay, that there is a harm, that there was criminal agency here.
I understand what you're saying. Okay, anything else?
No.
There is no crime.
I gotta get
Again, how am I supposed to respond to how many points are you going to make?
What a whiny little bitch.
before I'm allowed to
Well, I'm
respond.
addressing
Hold on,
everything.
hold you stop.
How many
Mr.
points?
Pierce, you keep interrupting, and I've overruled your objections and
Sir.
authorized you to make a response when he's finished. On
How
your
much
motion.
time should I allow to go by before I'm allowed to respond?
I gave you an opportunity to speak. You said the motion stands on its own.
Should I wait 1 minute?
I proceeded to let him respond to your motion. I asked you if you wanted to argue anything. You said, no, the motion stands
Sir.
on its own. So I asked for his response. He's giving his response.
He is giving-
There's no need to object at this point.
There-
You could bring up all the points you disagree with when he's finished.
Sir,
So please don't interrupt
I'm
me
only
when we get through
objecting
this.
for the efficiency of the time of the court. If he says something that I know for a fact
As I waste the time of the court, I just want to say that I'm just objecting for the efficiency of the time of the court.
is blatantly untrue, but I don't say anything, now the court believes
There's nothing to see, Otis. There's no. It's just black. He's been authorized to uh, audio record only. So that's why you can't see anything. See, there's stuff, but but the video is just it. There is no video. So you have to look at my pretty face, I guess. Well, instead of anything. This is one of those things where you can just kind of listen to it while you, I don't know, manually masturbate farm animals or something in the background.
that, then I have to wait for my turn, then we have to go back and correct it all. It's just so much easier if I just say, there is no victim here, a dog is not a victim.
So yes, a dog is not a victim. Uh, a dog is chattel. A dog is property, and so it is a property crime, and the harm is to the owner of the dog. So the owner of the dog is the victim, and but the state is the prosecutor, and the state has a vested interest in keeping law in the state. So I don't know why I say there's no victim, because you have two victims. You have the property owner who was denied their chattel by you shooting their dog, and you also have the state who had its laws broken. So there are two victims in this particular case.
I'm presumed innocent, therefore...
You need to stop talking.
Okay.
You're presupposing what the court's responsibilities are, and the court hasn't made up its mind on anything. That's why we're having the hearing. He's entitled to say things, and if you disagree with him, you're going to have to point that out when I give you a chance to respond.
Okay.
Go ahead, Mr. Murphy, finish your argument.
Thank you, Judge. Judge's third point.
This is a good tactic, though, being an obstreperous asshat, because he might be trying to throw the prosecutor off of his game, maybe trying to push the prosecutor to finish fast. So, I mean, this can be a tactic. I've seen attorneys use this kind of object to everything tactic just to throw opposing counsel off. But in this particular case, I think Common Joe is just an asshole, and he doesn't know how to keep his mouth shut.
Is talking about lack of jurisdiction, saying his motion says because there's no corpus delicti, there is no crime. So that's the basis for lack of jurisdiction. There is jurisdiction. We're alleging that this occurred in St. Charles County, and on my previous argument, there is corpus. Paragraph 4 says that this case is not in any real sense adversary. Because if there was a true adversary against the alleged defendant, it would be laughable to try to even discuss causation because the defendant is not accused of causing anything real or imagined. And then he also, very next line, there's no adversary unless a fiction offense ostensibly acting through Officer Tanner McMillan. There is no Tanner McMillan here. This is the problem with this ChatGPT. This person doesn't even exist.
This wasn't written by ChatGPT. I just told you it's 12 years old and it's been
Mr.
given...
Pierce, you can't interrupt him. Please don't.
Let him lie on the record. Okay.
Please don't, Mr. Pierce. You can respond.
No truth allowed. Got
I'll
it.
give you the opportunity. Please.
Got it.
No truth allowed.
Judge, the main line here is because the defendant is not accused of causing anything real or imaginable. We're alleging.
Yes, he is a soft sit. Yes, 100%. I don't know why you're late to the game on that, but he absolutely is a soft sit.
The opposite that he shot the doctor. So that's the end of my argument there, and that is alleged.
There was like this soft sit master, Mark Stevens, who taught a lot of this shit, and I'm guessing that Ethics Instead or Common Joe or Dear Missouri Jury, whatever he's calling himself now, was an acolyte of that. not realizing the terrible, terrible success rate that this particular line of bullshit has.
Our information as well.
Right.
And then the final paragraph, no
And not to spoil it for you, but the case is still ongoing, so this was obviously denied. So there you go.
evidence of presence within state and laws applicable.
Oh, I love the paper shuffling.
Of the city
Ugh.
or not applicable to me. This is alleged to have occurred in Winslow, which is in St. Charles County. I would just end my argument there.
Great, I would like to respond when you're ready, Judge.
There is actually one more paragraph, paragraph
Oh, we're
6.
not at the end.
It says court's jurisdiction not enlarged by police authority or custom. And Judge, there's no case law or any rules that he's citing as backing this argument.
Is that it?
Yes, Judge.
So courts, at least in my experience, except for like family law, you don't have to have citations to authority. But generally speaking, any proposition that you make in like a civil matter or a criminal matter, if you don't have an authority to cite to for that proposition, then the court doesn't even have to consider it. The court can just be like, well, you haven't given any authority for this proposition, so I don't have to consider it. There you go.
Mr. Pierce, you can respond to
Great.
his response to your motion.
I just want to remind the court that I'm speaking plain English here, and apparently this lawyer, Murphy, is not paying attention closely. I stated that this motion is 12 years old and has been given to dozens, I would say hundreds of judges across
Hundreds of judges. How often do you get in trouble, son?
this country and other Western-speaking world, and judges have approved it.
What do you mean approved it? So normally a motion is somewhat fact specific. Like in this case, the person didn't have jurisdiction because of X, Y, and Z. In this case, the person failed to state a cause of action because they failed to allege all of the elements of this crime, which are A, B, C, and D. You know, so like saying that another judge in another jurisdiction looking at a different case with different facts and different laws accepted a motion is fucking meaningless, because this judge is using the facts in this case and the laws in this state to determine whether or not this motion to dismiss is successful or not. And so just because some other judge in some other state, like this is an appeal to authority, but it's not even a valid appeal to authority, because most law is appeal to authority. You look at like appellate decisions, and you say, okay, so in this case with similar facts, the judges in the courts of appeals for this state that I'm in said that this particular law should be determined or interpreted in this way. So that applying that to my facts, I come out with this. Just saying that some other judge in some other state, or even hundreds of judges, have looked at this is a bad appeal to authority, because the authority that there's those judges and those cases in those states don't have power over this judge in this case in this state, whereas the Court of Appeals would.
I myself was the first person to ever get a judge to grant this motion, dismiss all charges,
Well, good job.
even after the prosecutor argued, just like Murphy did, as to why jurisdiction, a definition he's using that does not apply here, because jurisdiction has different definitions, and I'll explain that shortly.
Ooh, I can't wait to hear
A
his
judge
explanation
granted
of
this motion to
jurisdiction.
dismiss all charges of a Class A misdemeanor and a year in jail threat, exactly what I'm fitting here today. That happened in Hilo, Hawaii, and you can call that courthouse if you'd like.
Oh, you can call
So
the
for
courthouse. Woo! Hilo, Hawaii.
Mr. Murphy here to say that
Let me just be perfectly clear for the slow boys in the class. A judge in Missouri does not give a single shit about what a judge in Hilo, Hawaii did in a different case 12 years ago. Not a single shit. Not even the least huff a fart off of a single shit.
that all these different arguments that he's using in the court are not valid because of his reasons this and that reasons this, I would subject every reason he's given to the question, upon what factual evidence do you rely to form that conclusion?
Upon what factual evidence? So you're using the wrong words. And again, this is the problem with pro se litigants is they use the wrong words. You're not looking for factual evidence at this point. You're looking for what does the complaint allege. On the motion to dismiss, you're looking for what does the complaint allege. Motion to dismiss is based on the complaint, on the information, on whatever document the plaintiff or prosecutor or petitioner is used to get into court. A motion to dismiss says the stuff on that document is insufficient. And all the stuff on that document is going to be are allegations. They're all allegations. And so there is not going to be any factual evidence at this point. Factual evidence in a criminal case is at trial. That's when the prosecution lays out its factual evidence. And that's when the defense lays out its factual evidence. And that's when the jury decides that which of those facts they're going to believe and which of them they're not going to believe, and how much weight to give each fact. And then they're going to determine whether or not you're guilty or not guilty. That's when factual evidence comes into play at trial. On a motion to dismiss, you're dealing with allegations. Do the allegations, as stated in this case, I think it was an information or an indictment, I don't remember which, are the allegations contained on that document that started this whole criminal case, are those, if true, sufficient to allow this to go to trial? That's all they have to do. They have to allege that the crime happened within the territorial jurisdiction. So like if it's a city law, then they have to allege that it happened within the territorial limits of the city. If it's a state law, they just have to say that it happened within the state. In order to be in that court for venue purposes, that court might not have jurisdiction if venue is incorrect, so they would probably want to allege it happened in the county too. They have to allege all of the facts that, if true, would prove every element of every crime that he's being charged with. That's what they have to do. I don't know what the fuck he's talking about. Factual evidence.
Or is that merely an opinion?
It's an allegation. It's an allegation. It's not an opinion, it's an allegation.
You have a victim and it's a non-human victim.
The owner of the property is the victim.
That is problematic from the jump.
Problematic? Why is it problematic? What law? What law says that's a problem? Are you saying that states can't have animal cruelty laws?
Does this court presume me innocent or does it not? Because it claims
It presumes you innocent for the purposes of trial. It doesn't presume that you're innocent if the state has met the showing for probable cause. You don't get to walk away. That's a sufficient showing of guilt to maintain this criminal action to trial. Is just probable cause. That is the burden of proof on them. The presumption of innocence means that the state is carrying the burden of proof. That's all presumption of innocence means. It's a burden of proof. Is he in custody? No, he's not in custody. That's a $2,500 bond he was looking to get back. So all that presumption of innocence means is that if the prosecution fails to carry its burden of proof, the defense doesn't have to do anything. That's the burden of proof. That's what presumption of innocence means. It's burden of proof. And so in a lot of cases there are things similar. Well, even in a civil cause of action, you are presumed at the beginning, if you're the defendant in a civil action, to not have committed the tort or the breach of contract or whatever. That's the presumption. The burden falls to the plaintiff to prove in civil, generally by preponderance of the evidence, that you in fact did commit the tort or breach the contract. So I don't know why these soft-sits can't get it into their head. Presumption of innocence is a burden of proof. It says that the burden of proof is on the prosecution to prove all the elements of the crime beyond a reasonable doubt at trial by probable cause before trial. That's the burden of proof. That's the presumption of innocence.
Claims to presume me innocent, but in all actuality, the way it speaks, the language it uses, calling the woman who owns the dog victim one in all paperwork, V1, it's prejudicial. It is biased.
See, the victim was the woman who owns the dog. Wow, that's crazy. That's crazy. This guy, Common Joe, is like a big property rights guy. You just took someone's property from them. That's why they're the victim.
It is not impartial, and it favors a finding of guilt.
It is impartial because the prosecution had to show they had to show probable cause. The burden of proof was probable cause for this to get to the point where it's at now. There either was a probable cause hearing or there was a grand jury hearing. I don't know which, don't really care, but there was a hearing to get to this point where the prosecution had to prove probable cause that a crime was committed and you committed it. And the next step is trial, where the prosecution has to prove beyond a reasonable doubt that a crime was committed and you committed it.
Guilty. This is self-evident and irrefutable, especially.
It's self-evident and irrefutable. No, it's not, because you don't understand the words you're using, which is why you shouldn't be using ChatGPT, because you don't even understand the fucking words you're using.
In the court of public opinion, you're having a lawyer.
You're not in a court of public opinion. For the love of God, you're in a court of law. You're in a court of law, and you don't understand the law. You don't even understand public opinion, because most people don't want people out there shooting dogs unless they're being attacked, in which case it's excusable. But that is an affirmative defense that you're going to be trying to raise.
Lawyer here saying that, and this, let me make this point, and I've made it at least a dozen times in this very courtroom over this hearing, and I want this.
Well, if you've made it a dozen times and it's failed every single time, then why the fuck are you wasting everybody's time making it again?
To be the last time I have to make it. Please, everybody.
I want it to be the last time I have to make it. Give me my way, Judge. I want this to be the last time I have to say this. You don't have any power in that courtroom, dude.
Pay attention. There is a mass.
You just fucking told everybody to pay attention.
To be the last time I have to make it. Please, everybody, pay attention. There is a mass confusion going on as to the word jurisdiction. It has many different definitions.
It does. It does. Oh boy, are we going to get a knowledge bomb dropped on us by Common Joe?
Now, officers of the court are using a convenient definition of it that does not apply here.
A convenient definition? What are you saying? Are you saying the court lacks personal jurisdiction, territorial jurisdiction, subject matter jurisdiction? Which one are you talking about, sir?
And they know in their legal training that it does not apply here, and they're attempting to manipulate and take
What legal training have you had to know what they had in their legal training?
advantage of me, who stands here without a law degree and without the assistance of counsel, by trying to conflate and confuse the issue that says jurisdiction is this geographical border issue of lines on a map. And hey, that's the...
Well, that is one issue. Territorial jurisdiction is, yeah. But he also talked about, the other attorney talked about how, the information of the indictment or whatever it was also alleged all the causes of action, all the elements of the crime.
It settles the issue. Jurisdiction has another definition. Everyone here who hears my voice already knows this. I am an intelligent person who doesn't have
That's debatable.
to go to law school to be well informed as to what...
Well, so let's just get this straight. You're well informed. You know more than the judge, and you know more than the prosecutor. But you need ChatGPT to help you defend your case. I don't know. There's something in that logic loop that he's got there that just doesn't sink in with me. And it's maybe because he's smarter than me and he can figure these things out when I can't. But that doesn't seem to make a lot of sense to me.
What goes on here? Jurisdiction is the right to impose upon somebody. If you think that's foolish and
Well, yeah, jurisdiction. So if the court if the court has territorial jurisdiction, and if the court has subject matter jurisdiction, and if the court has personal jurisdiction means jurisdiction over the person, i.e., the power to make a judgment that is binding on the person, so power over the person. Yeah, and you're in that courtroom. Yeah, the court has personal jurisdiction over you. Like, I don't get it. Like, I don't get it. Yeah, the court has the court has power over you at this point. The court has the ability to make an order that binds you. Yes, the court has personal jurisdiction over you.
True. Let me just give you a perfect example of what the military does. As a former pilot in the United States Air Force, I can tell you that I signed a document to the UCMJ that said they had.
Well, okay, so again, he's misunderstanding things. The military gets authority over you. The military courts get authority over you uh, on the basis of you joining the military. So so yes, but the the military courts are different because they're a court system that applies to military members only, and it has a whole different uh, bunch of statutes and rules that apply to it. And I'm not really familiar with it, but I do know that there are things that are crimes in the UCMJ that aren't necessarily crimes in states and things like that. So it's its own little thing. But essentially it's like going to work. If you go to if you get hired on by a company and you sign the contract to work for them, well then you're bound by their rules, and their HR can make decisions on you. And essentially it's the same thing. If you join the military, the HR is kind of like the military court system, and they can make rules that bind you. But trying to analogize the state of Missouri with the UCMJ and the military courts is that's an interesting tactic to take, uh, because Missouri courts have jurisdiction over you if they have subject matter jurisdiction, if they have territorial jurisdiction, right? And but the most important thing for a Missouri court would be if they have personal jurisdiction over you. So if you get served process in that state, or if they have some other method of getting personal jurisdiction over you, yeah, then they can make a judgment that binds you. So yeah, like one of the things that a Missouri court would look at would be like, uh, did the person do something directed towards our state, or towards someone in our state? Uh, did that thing break the laws of our state? And then the next question is, can we get personal jurisdiction over them? Like for a civil matter, maybe they allow personal jurisdiction by mailing a copy of the summons and complaint by first class mail return receipt requested or something like that. Maybe they allow that, but that's how the court would get personal jurisdiction over you.
Jurisdiction if I were to perform any kind of a crime or anything, whether I lived on base or off. The geographical boundary had absolutely nothing to do with it. And if I committed a crime, all of
Well, sure, yeah, I suppose. But then again, that's a whole different ball of wax, because the state of Missouri is a geographically fixed area. So in order for you to violate the state law, or in order for a Missouri court to get any jurisdiction over you, there has to be something that targets that state. I mean, in theory, like it is possible to violate Missouri law out of state by doing something directed at somebody in state, but so again, Missouri can reach out and touch someone pretty much anywhere in the U.S., but normally it's within the state. You have to commit the crime within the state territory. But again, if you target, like if he had if he lived in, I don't know, Texas, and he sent like criminal threats to someone in whatever this county is. What was this county? Uh, to someone within the 11th Judicial Circuit of the state of Missouri, St. Charles County. There you go. Uh, if he had sent like a criminal threats to someone in St. Charles County, then the state of Missouri could like issue an arrest warrant, and if for any reason they managed to catch him, they could have him extradited to Missouri, where he could face charges. So yeah,
The local police might temporarily have custody of me. Believe you me, everything would be turned over to the Air Force and the
well, so if you violate state law as a member of the military has jurisdiction over you, yes, but the state also has jurisdiction over you. Now, normally they won't double dip on the prosecution, but they could. They could. They absolutely could. Federal law and state law. I mean, like if you commit a federal crime that is also a state crime in a state, like a terroristic act or something like that, uh, the state can prosecute you and the feds can prosecute you. Uh, but normally one or the other of those will be like, we'll just let them deal with it. But they can both prosecute you and they can both convict you and they could both impose sentences on you. And that could get pretty sticky because like if you get a 40-year sentence from the feds and you get like a 20-year sentence from the state, well, you're probably going to serve your 40-year federal sentence first, and then they'll transfer you to the state where you could serve out your 20-year state custody. I mean, they could do that. So, yeah. So again, he doesn't even know what he's talking about.
military police. That is the form of jurisdiction I am speaking of. I am tired of people, both the judge and lawyers, conflating another definition to presume I'm meaning something that I do not mean. Mr. Murphy is attempting to manipulate and deceive this court because he knows exactly what I'm talking about, because I've had communications with him in person, left messages for him on the phone, and I visited him in his office just yesterday where I finally got discovery.
He's doing a terrible job of arguing his motion, by the way.
After a year of this case ongoing, finally get discovery that includes body cam footage videos that I've been requesting from day one through the Missouri Sunshine Law, a law that this officer of the court has been shirking the entire.
Why would you request them through the Missouri Sunshine Law? As the defendant, you have the right to have all of the evidence given over to you. The prosecution might do a motion to restrict some of the evidence in certain cases, and normally, but the defense has an obligation, or the prosecution has an obligation to give it to you. You don't have to file a motion under the Missouri Sunshine Law. I mean, there's a requirement that I think it's based on the U.S. Constitution. I think it's Brady. I think it's Brady, but I could be confusing it with another thing. I wasn't actually prepared for this particular line of argument. I think it's Brady, but the prosecution has to give you all of the evidence that they intend to use and any exculpatory evidence. So they don't have to give you everything. They just have to give you all the evidence that they intend to use and any exculpatory evidence, is my understanding. Could be wrong. Take it with a grain of salt. But he says you got it. So congratulations. I guess that makes his motion to compel discovery moot.
Time purposefully, and he's doing that as well as anybody else of power in this courtroom is doing it, because there's absolutely zero accountability whatsoever for both judges and prosecutors in this state. How do I know that? How can I make that claim? Bold evidence. I haven't done it.
Dude, like you've gone so far afield of arguing your motion. Like, holy shit. Like, this is just stream of consciousness bullshit.
An investigation over the past several months to find out.
And I don't know what he's on. I mean, he must be on something, because this is just this fucking crazy stream of consciousness rambling, just point to point to point with no apparent connections between them.
Exactly what happens to these people when they abuse their authority and they violate the law. Laws that are written in the hallway, statutes and codes posted. What happens in the investigation I found out by talking to the police department of several cities, the sheriff's office, the bailiffs here yesterday, the buildings across the street. I've talked to the state AG office. I've talked to the commission on the disciplining judges and removal and retirement. All of them say that that commission has the power. That commission says they have no teeth and no power whatsoever to do anything. And even though I filed 3 complaints with them, early this year, I did not get answers until less than a week ago, because I've been hounding them for a month. My point is this, and then I'll stop. There is zero judicial oversight, and there is zero prosecutor oversight or.
This is a motion to dismiss, dude. This isn't a motion to punish the judge or the prosecutor. Argue the fucking pending motion, you idiot.
Consequences for people who are in these positions and blatantly break the law. The jurisdictional issue has to do with the right to impose upon me and not a
They have, they have, they have you there. They have you there. You're there. Here is your evidence of personal jurisdiction, sir. You're in the fucking courtroom.
geographical boundary, and I would appreciate it if every officer in this court and agent of this court would not insult my intelligence further by pursuing to conflate these two issues. Thank you.
Oh, Jesus. What a fucking retard.
Okay.
What a fucking retard. Oh,
Briefly.
Very briefly, Judge.
I should have brought bourbon
We
in
have
here.
tried to get him discovery on numerous occasions. We even mail it to him, that is, in the basement. We mail it to him. So when I asked him about that address, he told me that's just the address as far as the government is concerned.
Okay, well, that's a different issue, Mr. Murphy. That's not,
So I'm just trying to,
So he's complaining that it took forever to get discovery to him, but the prosecutor mailed discovery to him to the address that he had on file, and then this asshat's like, yeah, that's just my address as far as the government is concerned. So he doesn't even fucking live where he gave him the address to. Holy shit! Why am I not getting discovery? We mailed it to your address. That's just my address for the government stuff. Well, you should fucking check the mail there, dude. You should fucking check the mail there.
protect our own.
no, I understand that, but that,
Judge, Mr. Murphy brought up this issue of other discoveries he sent me. I have evidence right here in my hand of that evidence. It is
well, let's not, we're taking up your motion to strike and dismiss the complaint for the various reasons that you.
Yes, sir, but
in the motion.
I'm responding to what he brought up. This stamp
No,
says July 14th. He gave me discovery on July 14th. That is 2 days before the July 16th bench trial date. He just gave me discovery yesterday for the hearing today. This is a pattern.
I cut him off because he wasn't, that
But see,
comment wasn't response to the motion that you filed, so there's no need for you to respond.
he brought up this issue.
Well, I understand that, and I didn't take it up. I'm just taking up the motion to strike the complaint or dismiss the complaint for
Oh my God, this is
the
fucking
reasons that you cited.
I would like
terrible.
to respond then.
In your, well, you just did.
I responded
You have
to-
more to respond to?
I responded specifically to information that the court is required to know, record that I wanted to make so that it is aware of the abuses that are ongoing.
This is in regards to your motion to strike and dismiss.
Because Mr. Murphy
It's
brought up
not.
additional issues, I had to comment on those additional issues. I will now restrict my information to this, and I will be very brief, I promise.
No, you
We're
won't.
talking a matter of a few sentences. When it comes to this motion, this is a motion to dismiss for failure to strike, dismiss complaint. This goes hand in hand with the verbal motion. It is identical to the verbal motion that I have been making with you and every judge I come across on day one. And it sounds like this, and I know you remember this. You presume me innocent, you presume me innocent of every element. Jurisdiction is one of those elements, therefore you presume me innocent of jurisdiction. And all I've ever done is to investigate. I'm not arguing or making any claims, I'm just investigating by what
Again, at the motion to dismiss stage, I'll call it a complaint for lack of a better word. All the complaint has to do is allege. All it has to do is allege. You presume innocent? Yeah, they have to prove it. Well, they've proved it by preponderance of the evidence. That's why you're there. So the next step is either show some defect in the fucking complaint or move on, dude.
mechanism did that get switched to where I'm presumed innocent of jurisdiction, but now I'm not. And now you can impose upon me and threaten me with bench warrants and armed men that can come and extort me and take my freedom from me. That's what I've been asking. That's what this refers to.
Oh.
So all I've asked is, has
I
the
need to
prosecutor
start drinking.
provided any factual evidence regarding this element of jurisdiction that the judges, plural, presume me innocent of? And the answer to that question is no. So my motion to dismiss all charges because of that lack of failure to file a proper case.
So essentially what he's trying to say is that in order, in Common Joe's view of the law and the way a criminal case has to be brought, is you have to start off with the trial because the prosecution has to prove everything. And then do you get another trial later? Like, is there two trials? Do you have to have an initial trial for the prosecutor to prove by factual evidence everything? Because that's what a trial is. That's where all the evidence is presented, and the trier of fact makes a determination. So, do you need two trials? This judge is weak. The judge is being very nice to a pro se litigant. That's I'm not saying he's weak. I wouldn't say he's weak. He's certainly not controlling his courtroom very well, but he's also at the same time recusing himself. So maybe he is weak. Yeah, maybe he is weak. But who knows? Who knows what will happen next? Because if you don't think judges talk, they do. People are humans. Humans talk. So this is getting sent to the chief judge for this district, the 11th Circuit, I think it was, and I'm sure that the next judge will probably be a better fit for this kind of litigant.
That motion I have moved to get dismissed.
Hold on one second, we're in the middle of something. Go ahead.
This motion has to do with that. When I ask, has the prosecutor provided any factual evidence regarding the element of jurisdiction as
Doesn't
of yet
have
to the
to.
court, yes or no?
Judge, it's alleged in a probable cause statement that it occurred in Wednesday. And being in this county when that
may I be allowed to?
happened gives
I can't interrupt you. You say I can't interrupt you, so please respect the same rule for yourself. Yes, I will. I will right now. Grant me a moment to retain my thought process. I'm here without the assistance of counsel. I just need a few moments.
He's just got to keep bringing that up.
The verbal motion that I have made is hand in hand with this written motion. This motion is currently and always has been unopposed by the prosecutor.
He just
the
opposed
only
it.
way the prosecutor could oppose this motion is to commit an action to provide documentation of jurisdiction that the judge is presumed I'm innocent of to the court. I'm not asking what's written on it. I'm not asking is
Nope,
it legit or
doesn't
not.
have to do
I'm not
that.
asking anything about it. I'm only asking if documentation has...
See, he doesn't understand. A motion to dismiss is a motion based on the pleading. You're saying the pleading is defective. He doesn't have to provide anything. You're saying the pleading is defective. Okay, where's the pleading defective? Well, he hasn't produced evidence. He doesn't have to. You're looking at the pleading. Motions to dismiss are based on the pleadings. So if you look at the pleading, is there a problem with the pleading? There's no evidence. He doesn't have to produce evidence. You're looking at the pleading. On the pleading, there's no evidence. Like, you don't know, dude. You're so dumb. You don't know.
passed if the action, a verb, has passed from point A to point B. That's all it is, and I can't get an answer of a yes or no from Mr. Murphy.
Because you don't understand the questions that you're asking are nonsense. Your questions are nonsense. Does the court think am I presumed innocent of jurisdiction? Well, that is a nonsense statement. A better question would be, does the prosecution have the burden of proving jurisdiction? The answer to that question is yes. So essentially, the statement is that unless the prosecution proves at trial that jurisdiction is proper, then they can't prove all of the elements of the crime because one of the elements is going to be jurisdictional in nature, territorial jurisdictional in nature.
If he would just say, we're using this, we have filed this. It's not the judge's job to file a proper case. It's Mr. Murphy's. My problem is not with the judge. It's with Mr. Murphy's failure.
Okay, I understand. Okay.
He's not going to understand why the judge denies his motion.
Judge, I would just ask that you deny the motion.
And I would ask that you grant it, and if he denies it, on what grounds? And I would ask that you respond to the motion and then oppose it.
Okay. Let me.
You can't oppose it with words.
Yeah, you can.
This motion is closed. I've got the motion and I've reviewed it, and I've listened to your argument, I've listened to your response. Based on what you argued, Mr. Pierce, I'm going to deny your motion. I don't agree with you on your reasonings about jurisdiction of the case, and therefore, the motion is correct. I'm going to deny. The second motion was filed on July 7.
So the grounds are that you don't agree with it, sir?
Yep.
I disagree with your...
Oh,
your
okay. Could you give me the smoking gun? What's the biggest point you agree with specifically, sir? Just the one specific point you disagree with.
No.
Okay.
The motion's denied. I've read it all and
I'm not here to argue with you. I'm just recording your actions.
Oh, I'm just
So you
recording your
disagree, you're
actions.
shooting it down with no reason whatsoever.
Your motion to dismiss for lack
Okay.
of credible evidence is the other one that was filed.
I
on
predicted
July
this would
7th.
happen. You're going to hear nothing but denials here, and no grounds given. Here it comes.
Your motion to dismiss for lack of credible evidence filed on July 7th. Let's take that.
Oh yeah, let's take that up right now.
Proceed.
Okay, great. Have you read it?
Mr. Pierce, we've been over that.
Oh, I'm sorry. I'm not asking you.
And, you know, in Pierce's defense, in Common Joe's defense, one of the things that I normally do is I will ask the judge, have you read my motion or have you read my response? And in family law, it is a problem that judges often don't read the motion. I've never experienced it in criminal law where the judge hasn't read the motion, but I have experienced in family law where the judge has not read the motion. And I don't think it's an improper question to ask the judge. So I will say that in Joe's defense, I guess, that's not unreasonable to ask the judge, have you read the motion? But the big reason that I ask the judge, which is different than maybe what Common Joe's reason is I don't want to waste the court's time by re-arguing everything I've made. Basically, like in civil, like in law and motion in civil, most often the judge, like for Sacramento, the judge will issue a tentative ruling like the day before the hearing, and if you want to oppose it, you have to jump through some hoops. So I don't argue what's in my motion at that hearing. I argue the court's reasoning on the tentative, either to support it or to oppose it as best I can. Um, so in family law, if I ask the court, have you read my motion? Have you read the papers? Have you read my response? Whatever. Uh, if they say yes, then normally I won't just rehash the entire thing. So many lawyers just fucking rehash the entire motion or rehash their entire response. And it's like, if the court's read it, then I don't think you need to do that. But like, for example, if you're the opposition to a motion, normally it's someone files a motion, you file the opposition, then they get to file a reply. Uh, I will, however, even if the court has read it, I will make an argument maybe about how the reply got something wrong, because that's something that I haven't had a chance to respond in writing to. So it is. I do think it's appropriate to. Some of them are. Yeah, some of them are freaking terrible. I won't name any names, but if you're ever in, what's the court in Woodland? What's the court in Woodland? That is that Sutter County? I've had some bad experience. There's one family judge there that I have had nothing but bad experiences with because that judge doesn't know the law, shocking, doesn't know the law, and doesn't read anything, like literally doesn't read anything ahead of time. And then, you know, short cause hearings are supposed to be like 15 to 20 minutes max. And like, because everybody has to argue every part of their entire motion in front of this judge, like it's just a cluster. It's just a cluster. You can get there like you get there for a 10 o'clock hearing and you might be there till 3 in the afternoon. It's absurd. And the client pays for it. You're like, why can't the judge just, I don't know, read the stuff ahead of time?
disrespectful question. I sincerely know.
But really, this isn't your forum to ask me questions on what I have done and not done.
Oh, so I'll
I am the
presume.
decision maker. This is your motion. I'd like to hear it. If you wanted to stand on it on
Sir.
its own, like you did the last one, that's fine. If you want to argue your motion,
I don't have to argue anything.
okay.
Let me.
Then are you
No.
finished?
I'm not arguing in the sense that I'm not making a claim. I can respond to this motion. I'm happy to do so.
It's your motion.
I just want
Proceed.
you to know
Proceed.
that I'm not intending for you to take offense. I've had other judges, multiple dozens of other judges, who deny motions and don't even read them. That's where this is coming from, sir. It's not for you.
That's not the case here.
Okay, great. I'll note it.
You may proceed.
Note it for the record. Okay. Again, give me just moments to re-familiarize myself with it. It's only a page and a half.
I think this is the last motion we're going to hear him argue
Okay.
today.
So, what is going on here is that
'Cause I think I'm
obviously
gonna have
this
to have
motion
some
was filed
bourbon.
July 7th. Now, is the court aware that just yesterday, Mr. Murphy handed me a stack of papers over an inch thick and 2 CD-ROMs? From his office, I came here myself in person.
Mr. Pierce, the court isn't here to answer your questions.
No.
We're here to answer your
Sir,
motion.
I'm not asking the question of a court like it needs to answer to me. I'm asking to...
You can point out if you're making a point.
Okay,
So-
I'll do my best. Again, I appreciate your leniency because I am without the assistance of
I
counsel.
understand.
Carpet on the assistance of counsel still.
While denying you the assistance of counsel. Okay. So the motion here, basically, again, I'm not going to
Ugh.
restate the motion as in replace its words with my words, but in essence, what it states is that this motion should be dismissed, the charges in case should be dismissed for lack of credible evidence because
I can't do it. I can't do it. I cannot do it. Dismissed for lack of credible evidence. Well, I didn't think trial had happened yet. It is the job of the judge or the jury at trial to determine what evidence is or isn't credible. No evidence has been presented yet. So, yeah, I mean, this one's going to get obviously denied, and I just can't handle this anymore. So I'm giving up. Thanks for watching. I hope everybody had a wonderful Turkey Day. Um, I hope you were all as thankful as I am for all the good stuff in your life. And if you're not, well, I hope your life gets better. Make sure that you don't represent yourself pro se and have a wonderful, wonderful extended week.